Good morning, Your Honor. Thomas R. Ashley on behalf of Rashid, Bynum, who's the president of court to my left, and my co-counsel, Michael Ashley, who's also the president of court.
Good morning.
Good morning.
All right. The first matter we'll address is defendant's arraignment. Do I have an arraignment order?
I did just email it to the court clerk, Your Honor. It's been executed by all parties.
You're on a physical copy of it?
No, Judge.
You have it here?
When did you email?
Just a moment ago.
You want to send it to me, please? Did it pop up yet?
No, not yet. No, I don't have it.
Did you sign the?
I did, Your Honor. I signed the electronic copy that counsel pulled out.
Does anybody have?
It's a 1013. I had only electronically, Your Honor. The email was sent at 1013, so it may just be pending in the ethers.
I don't have it yet.
All right. Well, are you wearing a plea?
Yes, at this time, just for the record, Your Honor, the defendant's parents, Manisha Bynum and Randall Bynum, are appeared via Zoom. That's my understanding.
The family members are appearing by Zoom?
Yes.
It's a number of people on Zoom, Judge.
Okay.
On behalf of Mr. Bynum, Your Honor, I acknowledge receipt of the indictment. I reviewed the indictment with the defendant. He waives the reading of the indictment, enters a plea of not guilty with respect to all counts, and I request that the detention hearing be adjourned for 30 days, which reasons for which I have set forth in an August 25th letter, which I sent to the court.
All right. So we're going to enter a not guilty plea. He's been fingerprinted. I assume there are no immigration issues connected to this matter, right?
That's right.
And what's the plea offer, prosecutor?
Your Honor, the offer is a 50 with 30 to plead to count 1, murder. This offer has been relayed and discussed with the families.
Okay. Have you, at this point, considered any motions you want to file, Mr. Asher?
Your Honor, for the record, and I'll review my letter at an appropriate time, but for the record, Your Honor, we have received approximately 6,000 pages of discovery. So it's very difficult for me at this time to determine what motions we will file, but certainly we intend to file all appropriate motions, Your
All
Honor.
right. I'm going to bring this matter back for initial case disposition conference. How much time do you anticipate you'll require to review the discovery?
Judge, I am, well, first I'll answer your question, I'll say something in addition to that. In order to review the discovery before the 6,000 pages, I would think that we would need at least 60 days to do that. And the reason I'm asking for that, Your Honor, is that I have 2 murder cases that I'm supposed to try in the month of September back to back. So I'll need that time.
All right. So you want to come back at the end of October?
That would be fine.
How does that work in our calendar?
We can do October 30th.
Okay.
October 30th work?
Is that a Monday or Friday? Your
It's a
Honor?
Monday.
Yes.
All right.
That's fine.
Did we get the original over yet?
Yes, I emailed it to you and Tyree.
Okay. All right. The next matter we'll address is the detention hearing. We're scheduled this morning for a detention hearing. And just so I can create a clear, State, are you prepared to proceed with a detention hearing?
I am, Your Honor.
Okay. So my understanding is this. The defendant in this case was arrested on May 30th.
Correct.
And he was returned to New Jersey on July 27th. Now, Mr. Ashley has requested an adjournment, and one of the reasons he requested the adjournment is because he indicated that it was his perception that the state was sitting on the defendant in Virginia and wasn't bringing him back up here to New Jersey. The fact of the matter is that the reason the defendant sat in Virginia for 2 months is because he resisted his extradition. And I know that because I had to exemplify a governor's warrant to have him brought back up here to New Jersey. So the reason there's been that delay of 2 months is as a result of the defendant's recalcitrance and resistance to appear here in New Jersey. The This matter was then scheduled on July 28th for his first appearance at Central Judicial Processing, at which time the state moved for detention. On a pretrial detention hearing was scheduled for August 2nd. Mr. Ashley had filed an appearance on August 1st, the day before, so he requested an adjournment, of course, naturally, so it was rescheduled to August 4th. On August 4th, we were advised that Mr. Ashley needed more time for preparation, so we adjourned it another week to August 11th. On August 11th, we received a request again from Mr. Ashley that he needed more time to review the discovery, and he also was anticipating a vacation. So he needed more time, and I advised the state and the defense that this matter would be adjourned to August 28th, and everybody was in agreement on that scheduled date. Then, on Friday, at 5:17 p.m., Mr. Ashley filed a letter on e-courts requesting an adjournment, arguing that he needs more time. That there is voluminous discovery that he has to review. The fact of the matter is that this is a detention hearing, this is not a trial. And typically, detention hearings are conducted with limited discovery. That discovery had been, when was the discovery in this case, Ms. Gibbs, provided to the defense?
Your Honor, the discovery has been in InfoShare available to counsel since he entered his appearance on August 1st.
Okay. So the defense has had an abundant, well, has had more discovery than is typically available to the typical defendant due to the fact that there was a delay in bringing the defendant back up here to New Jersey. I understand the defense request, but I'm going to deny the application.
Your Honor, before you make a determination with respect to the application.
You want to be heard?
Yes, sir.
Yes.
Your Honor, I had a vacation which was already booked, and that vacation was for 2 weeks, and I returned from that vacation on August the 21st, 2023. So during that time, of course, I was not in a position to have reviewed the 6,000 pages of discovery. Assuming, and then this is in all due respect to the court, that the facts that set forth are accurate, certainly 6,000 pages of discovery is such that even if I had the discovery on whatever date it was available, certainly I could not have reasonably been able to review that discovery while on vacation. And also, I think in looking at the rule, as I understand it, the Rule 3:14-4A1 provides as follows. A pretrial detention hearing shall be held before a Superior Court judge no later than the defendant's first appearance, unless the defendant seeks a continuance, except for good cause. A continuance or motion of the defendant may not exceed 5 days. And of course, we're asking that we have shown good cause because, number one, the voluminous nature of the discovery, but two, and probably more importantly, is the complexity of the case. This is a case where there is no, is our position is that there's no identification of the defendant by any witnesses, so that the case essentially is a circumstantial evidence case. The 6,000 pages to read within less than 30 days, I think, is a quite onerous task. Certainly also, within that period, the defendant is entitled to call witnesses, number one, to apply the court with respect to any letters, with respect to the character and nature, with respect to the character of the defendant, for which we have not had a sufficient time. That we're also, as I may have said this before, we're entitled to call witnesses, and we're also entitled, Your Honor, obviously, to take a position with respect to the weight of the case. Now, as I understand it, one of the most important factors in a detention hearing is the weight of the evidence in the case. So with respect to that issue, the 6,000 pages that we received, assuming that we were able to receive it on August 2nd, and of course I had a 3-week vacation, then the fact of it is that 3 weeks, 2 weeks vacation. The fact is that we could never have finished in any way reviewing the 6,000 pages, putting together letters with respect to the defendant's character, and evaluating the strength of the case. It's just impossible. And I think that certainly implicit with respect to the detention hearing, if the defendant had the effective assistance of counsel, certainly this is a very important stage of the proceeding, and certainly I could not ever have been effectively able to represent him, assuming that I was not on vacation. The state has had many months prior to the indictment to review this case. They've had an additional 8 weeks, despite the fact that the defendant may not have agreed to extradition. So in effect, they've had many months to review the case and determine the weight of the evidence in the case. I think that certainly the defense has had less than 30 days, and I don't think that that is really fair to the defense. I think it's manifestly unjust to the defense. And I understand that we have a difficult burden. The burden obviously is that we must show, because there's a rebuttable presumption that the defendant will be detained. Therefore, we have to very high standard to overcome. And within that period of time that's been accorded to the defendant, assuming that he did, and I'm not questioning that, but did object to his extradition, it still would not have given us enough time, Your Honor, to review that, and also videos that are in addition to the 6,000 pages. Now, I think the law is quite clear that we are to be provided discovery, and of course we don't have at this point a probable cause issue, because the indictment trumps any issue with respect to probable cause. But all we're asking for is an opportunity to present the defendant's point of view and present his case in support of our difficult task of having to overcome the presumption of detention in the case. And I don't think, in all fairness, Your Honor, that the state cannot show any prejudice. There's no prejudice to the state. The defendant has been incarcerated throughout this entire period. He is now detained, and there's no reason that I can think of that would cause the state to be prejudiced in any way by my application. So, again, Your Honor, I submit that under the circumstances we have afforded those 30 days. Because at this point in time, we cannot reasonably argue effectively that the defendant should not be detained. Also, of course, the rule permits, assuming that we have additional evidence, assuming we have additional information, which we will certainly have soon, with respect to letters, and with respect to letters that would certainly deal with the issues of the defendant's character. It may very well be that we'll be in a better position to deal with the issue of what the weight of the evidence is. We question the weight of the evidence, but we're not in a position to effectively do that because of the fact that we haven't had a chance to read 6,000 pages. 6,000 pages is a lot of reading. Now, how could we really, and I'm saying this parenthetically, how could you expect the defendant and counsel to read 6,000 pages, review the 6,000 pages with his client, and then at that time collect all the letters in support, which we expect to have many letters of support to show the defendant's character and the likelihood that he would not flee, and the likelihood that he would not commit another offense, and the likelihood that he would not be a danger to himself or the community. To achieve all that within a period of however many days, I think would be, again, manifestly unjust. It would not give the defendant a fair shot at a hearing. I think the fact that we're talking about a hearing implies, whether it be this type hearing or any other type hearing, that the parties be able to be given a full opportunity to respond to what the issues in the case are. And certainly in this case, we have not received that full opportunity at all due respect to the court. And so that is my position, Your Honor. I'm still asking for those 30 days. I don't see how the state can conceivably be prejudiced by this.
All right, thank you, Mr. Ashley. Prosecutor, you want to be heard?
Yes, Your Honor, thank you. First, the state would like to make clear that we recognize the Sixth Amendment right that counsel is laying out to the court. And obviously, through every stage of this proceeding, the state respects the right to have counsel prepared and ready to move forward. However, what the state and what the defendant does not have a right to is to delay these proceedings and to stop this case from moving forward. The defendant has had, since the day that he was arrested in Virginia, on May 30th, 2023, the opportunity to obtain counsel and to obtain the discovery that we have been preparing and had available. And through that time was chosen to delay this process in Virginia for over 8 weeks while he fought extradition back to New Jersey to be held accountable for these charges. Within that 8 weeks, if counsel did not have an opportunity, either because he was not retained or because other counsel did not review it, unfortunately, that is for the defendant, that is an issue for the defense. However, the state here has continued to be prepared to move this case forward. We want to talk about a manifest injustice. The injustice is delaying this case for this family that is here, who has been ready to appear for each court date that continues to get adjourned. Each court date that Your Honor laid out, this family has been waiting to come to court to have justice for the victim here, their daughter, Eunice Junefort. To delay this case any further, that's where there's injustice. So the prejudice to the state is clear, that we want to move this case forward. We want to make sure counsel has all time necessary to review discovery when we talk about going to trial, when we talk about motion practice. But here for this detention hearing, the state is ready and prepared to move forward. I hear about letters, and I hear about all the information that counsel wants to present to the court. But as counsel has already stated, this matter has been presented to the grand jury. And on August 16th of 2023, a grand jury returned an indictment against Mr. Bynum for 3 counts. Count 1, murder. Murder of the victim here, Eunice Junefort. Count 2, unlawful possession of a handgun, a firearm that he used in count 3 to possess that weapon for an unlawful purpose by shooting the victim in her vehicle multiple times, causing her death. So at this point, Your Honor, the probable cause here, we've already established that. I understand counsel wants time to go through 6,000 pages of discovery, and frankly, the way that counsel has laid it out, 30 days wouldn't be enough. I don't know if 3 months would be enough, but I want him to have as much time as he needs to prepare. However, for this detention hearing, as the court has mentioned, this stage, limited discovery. Many attorneys have appeared with cases severe to before Your Honor and have been prepared to proceed. Why should this case be special? Why should Mr. Bynum get 30, 60, 90 days to prepare when every other case that comes before your court moves forward with the discovery that's prepared and defense counsel reviews it? So at this point, Your Honor, respectfully, the state requests for the detention hearing to proceed. And if counsel believes when he reviews through 6,000 pages that there's something that was either misstated by the state or inaccurate today, we can move to reopen. We all are very clear on the rules. If there is a piece of evidence or if there is a significant change, a material change that they want to bring before the court, we are able to do that. If there is information or witnesses that counsel believes are necessary, we can come back before the court. But at this point, Your Honor, the state is prepared to move forward with extension.
Judge, I want to make a point. No, just one thing. The defendant was indicted on August 16, 2023. So pursuant to the rule, that's at that point, that's when the issue of the detention hearing became obviously important and critical. So we've had essentially 2 weeks in order to get prepared.
Well, that's not a fair characterization. All right, we're going to proceed. Now, let me just be clear. Mr. Ashley had 2 weeks before he went on vacation to review the discovery. While he was away, his partner, who was here in court, had ample opportunity to review all the discovery. And when Mr. Ashley came back, he had another week to review the discovery. And frankly, we didn't receive any request for an adjournment until after court was closed on Friday evening. Just because, in this case, the defendant has the benefit of more discovery than is typically available to most defendants, and frankly, more time than most defendants receive, does not, in my estimation, constitute good cause. And the rule, 3(4)(a), as well as the statute, New Jersey Statute 2A 16220, make clear that unless good cause is established, a continuance may not exceed 5 days. And we've gone far beyond that. In the event, and I understand Mr. Ashley indicates that there's a lot of discovery in this case, and as in all cases, New Jersey Statute 2A 16219F clearly provides that the defense may reopen a detention hearing if, after review, Mr. Ashley finds information or evidence that would change the court's decision in this matter. And I haven't made a decision yet in this case, but were I to find that the defendant should be detained, he can reopen this matter at any time and raise those issues with the court. So we're going to proceed with this detention hearing. You can have a seat, and we're going to continue. It's now, just to be clear, the first issue we generally have to discuss at a detention hearing is the establishment of probable cause. But in light of the fact that the defendant on the 16th of August has been indicted, that issue is now moot because probable cause has been established by virtue of the indictment. So the next step in the process would be for the state, not the state, for the defense to establish, because this isn't a typical pretrial detention hearing where the burden would be on the state to establish by clear and convincing evidence. Since the defendant has been charged with murder in this case, and he faces the prospect of a life sentence, it is on the burden is on the defendant to prove by preponderance of the evidence that pretrial detention is unnecessary to reasonably assure his appearance in court when required, protect the community, and that he will not obstruct or attempt to obstruct the criminal justice process. So I call upon the defense to provide whatever facts, information, or details in support of their verdict.
Your Honor, certainly I'm not going to reiterate what's already been said. So let me just say this as far as I'm able to say this without reading all of the 6,000 pages. It's my understanding, Judge, that there has been no eyewitness identification of the defendant having shot the deceased. So that we're dealing with an issue now where there's no eyewitness identification, and that the state has now proffered that, irrespective of that, that they have a strong case. Now, again, without some proof that the defendant, or some significant proof that the defendant has in fact shot the victim, I submit that the fact that there's been no identification should loom large with respect to any decision that the court makes in this case. Now, also, Judge, although I have not read the discovery of the case, I did have an opportunity to read the affidavit of probable cause, and the affidavit of probable cause will have to suffice, unfortunately, with respect to my application. So, for the record, let me just say this based upon my analysis of the affidavit of probable cause. The affidavit indicates that there was video surveillance which captured the suspect allegedly fleeing from the scene in the direction of Hurston Road. Now, the question is that really the defendant was fleeing the scene? Is there a clear indication with respect to whether that was in fact the defendant that was fleeing the scene? Again, that's an issue which I think the state should have to answer with respect to its presentation. I haven't had a chance to see this video, but I admit that the video itself we have a right to challenge its accuracy, and we have a right to determine whether or not the state's allegation that it was in fact the defendant that was fleeing the scene, I think is very critical to whether or not this video has any probative value. The state has also indicated, at least in the probable cause application, that a witness described the suspect as a thin black male, possibly 5'10" or 6 foot, with ear length braids. Again, certainly that type of description would be one which would fit thousands of black males and has little, I submit again, a little of any probable cause, because that description is lacking in any kind of specificity that would be needed in order to suggest that this defendant was a person who was described by the witness as a thin black male, possibly, quote unquote, 5'10" or 6 foot. Also, in the affidavit of probable cause, it indicates that a witness described a white Hyundai suspiciously parked in a surrounding area minutes before the murder. Now, whether or not that's accurate, I'd have to again look and read that witness's statement, but assuming it did, there's no indication that this defendant was driving or this white Hyundai at any time. It only involves certainly a description of the vehicle, and I think that certainly it's very important to establish that it was in fact the defendant who was driving this vehicle at the time of the murder. And we have a right, again, to refute this contention. Then it's indicated also in the affidavit of probable cause that a, quote, questionable device, which I didn't understand quite what that meant. The word questionable is the state's word, not mine. So again, if the device itself is questionable, that would make certainly the statement that's included be equally questionable. But it says, and I'll quote, a questionable device was revealed through cell tower extraction records near the incident location at the time of the murder. Now, I think the court's well aware of what a cell tower extraction is capable of doing. Certainly the cell tower extraction, from my experience with respect to cell tower extractions, is that it only can deal with a certain radius. It does not and is not able to pinpoint the fact that this defendant was at a certain location. It can only say that within a certain radius, and I have not had an opportunity to reveal the reports, which I assume is in the discovery, but we know that cell tower records at best have a wide radius and cannot provide a pinpoint accuracy, and nor does the cell tower information provide one with an identification of the defendant as being the driver of the vehicle. Now, again, the affidavit of probable cause, and I quote, it was later determined that on February 1st, the device, this is the questionable device, the device traveled from Virginia to New Jersey, and after the murder, and immediately returned to Virginia afterwards. Now, it says Mr. Bynum's device was located, quote, again, in the area of Gondak Drive and Erskine Road immediately prior to the murder. That we have to examine, because I'm not so sure of the extent to which the cell tower information would provide a precise time. Assuming that it does, the best it could do is say that the defendant's vehicle, or a vehicle, I shouldn't say defendant's vehicle, that a vehicle was traveling in a manner which is set forth in the application and the affidavit of probable cause. Now, again, the defense, I submit, Your Honor, is entitled to, at this time, to indicate what that device was, what the capability of that device was, how accurate that device is, and how it connected to Mr. Bynum. There are other alleged facts which the defense also needs time to refute, and I think that given the circumstances, the state at this point is obligated to refute or at least support some, or indicate by its either witnesses or proffer that this information is correct. And what is also said again, in the affidavit of probable cause, is surveillance showed a white vehicle, again, not any specific reference to the make or model, simply a white vehicle parked on Gondak Drive. Again, no make, no model, no identification of the defendant, only that a white vehicle was parked on Gondak Drive. When? No, not stated in this application. Certainly, when we say when, we're talking about a period which is reasonably in the area of the time that the deceased was shot. And it also, as witness stated, that an unoccupied white vehicle was parked on Condo Drive. Now, of course, the state has an obligation to show that this unoccupied vehicle was in fact occupied at some point in time, and relative insofar as the time is concerned, was actually ultimately occupied by the defendant. There's nothing that would suggest that. They've said, again, in the affidavit of probable cause, that the video shows a dark figure, again, that's the quote, walking on the sidewalk in a direction of Czech Avenue from Condact Drive. Now, I think it's quite evident to the court, and should be quite evident even to the state, that to suggest that that dark figure, quote unquote, was in fact Mr. Bynum is a intellectual leap, to say the least. Certainly a dark figure does not in any way implicate Mr. Bynum, and certainly there's no indication that the defendant was identified as a person who was this, quote, dark figure. Also, the affidavit of probable cause, which I reiterate, Your Honor, is an affidavit, so that the person who said it is under oath at the time this is said. So clearly, this puts the burden on the state to verify at this time, since we are now dealing with the probable cause substantively, who this and what proof they have that this dark figure was in fact Mr. Bynum. Now, also the probable cause statement says a search of the victim's phone revealed a contact entered in her phone, and the contact is entitled King Ra FCN. And the state argues that this is a reference to Mr. Bynum. And now, assuming that that's correct, Judge, because now we're talking about facts and not just assumptions. Assuming that the victim's phone records reveal Mr. Bynum as a contact, I asked parenthetically, how does that fact demonstrate that Mr. Bynum actually shot and killed the victim? Obviously, the probable cause there is little or non-existent. Also, with respect to the affidavit of probable cause, it indicates additional records received reveal on the day of the murder, Mr. Bynum searched via internet Champion Royal Assembly Church as well as the area of Sayreville, New Jersey, and within days prior to the murder, what magazines were compatible with the Glock 17. So let's talk about that. According to what I do know, is apparently the victim was shot by the utilization of a Glock 17. So the state now argues that the fact that the defendant, assuming that actually did happen, did search the internet to see what magazines were compatible is certainly proof, very, very little proof, that it was in fact the defendant who used that Glock 17 or any Glock 17, and so that has like zero probative value. Again, the inference that the defendant killed the victim because he did on the internet seek information with respect to the church and her church. Again, this only bespeaks the fact that the state is reaching and that the circumstantial evidence that I've said so far is only indicative that the state's case is weak. The interest in the Champion Church and Sayreville is from evidence that is far from evidence that he killed the deceased. And I think that the state has an obligation to demonstrate that to the court. Also, which is, I think, very, very interesting, Your Honor, and know that in most cases, because the person was a lunatic, there is a motive that certainly that would abide the fact that Mr. Bynum would shoot and kill the deceased. At no time, understanding clearly that the case law indicates that the state does not have that burden, but insofar as the probative value and the extent of the state's proof, there is no indication whatsoever that shows that Mr. Bynum had any reason whatsoever at any time to shoot the victim. None whatsoever. So now, if the fact that there is no motive seen, I think also militates against the strength of this circumstantial evidence, which I submit to the court, predicated on my review of the affidavit of probable cause. This circumstantial evidence is in fact insubstantial. The last paragraph of the affidavit of probable cause is somewhat confusing. It states, records show the Bynum device, this was the questionable device, which is not my word, their word, traveled through Easy Pass at the same time as the white Hyundai bearing Virginia license plates. Now, assuming that's true, does that mean that that same vehicle traveled to the location of the shooting, and therefore Mr. Bynum was the person who was involved in the shooting of the individual? I mean, the answer is clearly no. And certainly, again, this is circumstantial evidence and I'll concede that you should look at all the circumstantial evidence, not in a vacuum, but in its totality. And what I'm saying is this is only indicative that if you don't have proper probative value with respect to one, it is not more probative because you say a number of things which don't have probative value. It's not like 1 and 1 is 2. That's not the case here. So here, then it says that the registration hit the license plate readers in a, quote, again, this vague statement, in the same area. So the state's basic proofs based upon what is set forth in the affidavit of probable cause is that they have at least some proof that Mr. Bynum was in the area, quote unquote, where the shooting occurred, which we certainly don't acknowledge that, but assuming that's the case, that's far from proving beyond a reasonable doubt that Mr. Bynum committed the crime. Now, also in the affidavit of probable cause, it indicates a registration inquiry of the white Hyundai Elantra revealed to be one of multiple vehicles registered to 2 individuals. Now we find out that actually Mr. Bynum did not own or had, at least based upon what is set forth in the affidavit of probable cause, any connection to these vehicles. And so in a further statement, which is vague, intentionally I assume, because certainly my adversaries are quite competent, one of the registered owners listed the white Hyundai online for rental purposes. That's what it says. And Bynum's call detail records reveal communications on January 31st, a day prior to the murder, with a phone number related to one of the registered owners. And I read that and said to myself, well, exactly what does that mean? And is the state prepared to show or prove that one of the owners did rent this vehicle to Mr. Bynum? Well, that's unclear, and because we haven't had a chance to review the 6,000 pages, unfortunately, I'm not able to allude or to determine what the actual proofs are. But we do know the fact that Mr. Bynum allegedly in his phone sought to rent the vehicle is questionable in terms of whether he in fact did. The affidavit is vague in that regard. So, Your Honor, given the fact that I feel as though I'm fighting this detention hearing with one hand tied behind my back, the court may not agree, but certainly I feel that way, that we now have raised these issues and the state, although it has a rebuttable presumption of detention, still has to show the court that the evidence is strong enough in order to support that rebuttable presumption, that is accurate enough in order to support their rebuttable presumption. I feel that based upon what I read in this probable cause hearing, this is highly circumstantial and doesn't really prove that this defendant beyond a reasonable doubt shot anyone at any time. All this is a bunch of facts. Everybody says, well, gee, that looks suspicious, but that's not what the standard is. Unfortunately, in America, it's not a standard of whether it looks suspicious. The standard is whether the state can represent to the court that defendant will be found guilty beyond a reasonable doubt, and they haven't done that, at least with respect to the probable cause affidavit. And again, I recite for maybe the fifth time that I've not had the opportunity to review the 6,000 pages. And when I do, Your Honor, it may very well be that I will come back with what I perceive to be newly found evidence because of the fact that I've not been able to review the 6,000 pages. And thank you for your indulgence.
Thank you, Mr. Ashley. State.
Thank you very much, Your Honor. To provide clarity to the court and counsel in regards to the state's proofs, and frankly, because one of the requirements under the statute when we consider detention is the weight of the state's case, please allow me, Your Honor, to provide the probable cause and what was presented to the grand jury in regards to the state's case. Specifically, on Wednesday, February 1st, 2023, at approximately 7:22 p.m., the Sayreville Police Department received several 911 calls reporting a shooting in the area of Check Avenue, located in the Parlin section of Sayreville, New Jersey. Officers responded and located the victim, Eunice Junthor, in a vehicle suffering from multiple gunshot wounds that she ultimately succumbed to at the scene. Officers secured the scene, canvassed the nearby area for video surveillance footage, and attempted to locate witnesses. Detectives from the Middlesex County Prosecutor's Office responded to process the scene. While processing the scene, 14 cartridge casings of 9mm ammunition were located in the roadway of Check Avenue. One witness at the scene contacted the Sayreville Police Dispatch regarding a white Hyundai parked at the front entrance of the Harbor Club complex located on Gonduck Drive in Sayreville, and indicated upon arriving home on February 1st, 2023 at approximately 7:15 p.m., she noticed the car parked in a spot that would not be a normal spot for anyone to park. A second witness indicated that he was home in the area of Check Avenue, located in Sayreville, in the Camelot-Lemaire complex at around 7:20 p.m. when he heard multiple gunshots outside his home. This witness stated that he looked outside and he saw a man with a pistol shooting multiple rounds into a vehicle. This witness described the shooter as a thin, black male, possibly 5'10" to 6 foot, in height having ear-length dreads or braids. After an extensive investigation, a cellular phone record showed, and when we talk about this questionable device that counsel has been mentioned to in the affidavit of probable cause, when the state says questionable, it means this device, out of all the devices that were in that cell tower dump, it became very questionable that this number with the area code that it had, a 757 coming from Virginia, matched a number that was related to our victim.
This is a cell tower that located this phone at the scene of the homicide?
In the area of the scene of the homicide.
Was there a geofence in this case?
There was, Your Honor.
I guess you'll get into that.
Yes, and the fact is, so when the state says questionable in the affidavit of probable cause, it became questionable for the state to investigate that particular number further. Not that the state was not aware of what device it was a cell phone tower dump, meaning we were dumping cell phone numbers. We were dumping any activity that was pinging off of those cell phone towers. Therefore, and as Your Honor mentioned, that geofence provided that information, and it became a question to the state to look further into that particular number and the cellular device associated with it. Now, on February 1st, this device was determined later to be a mobile device that was traveling from Virginia to New Jersey and immediately returned to Virginia after the murder. Additional records revealed that the device was associated with Rashid Ali Bynum. Applications running on Bynum's device placed him in the area of Gondak Drive and Ernest Road prior and subsequent to the murder. A search of Ms. Junfor's phone revealed Bynum as a contact with the acronym FCF. FCF is believed to be an acronym for Fire Congress Fellowship, a church with which the victim and Bynum were previously affiliated with, which is also associated with Champion Royal Assembly, the victim's current church. Additional records reveal that on the day of the murder, Bynum searched the internet for information on Champion Royal Assembly Church, as well as the area of Sayreville, specifically Parlin, New Jersey, and in days leading up to the murder, he searched what magazines were compatible with a Glock handgun. It was also determined that as recent as March 2023, Rashid Ali Bynum was a black male, had a slim build, tall, with ear-linked dreads, consistent with the description provided by the witness of the shooter at the scene of Ms. Junfor's murder. Additional records corroborated Bynum's device location the day of the homicide. These records showed Bynum's device traveling through an Easy Pass tolls the same time as a four-door white Hyundai Elantra bearing Virginia license plates. The registration hit automated license plate readers in the same area as Bynum's device records located throughout the day in Newark, New Jersey, Woodbridge, New Jersey, and Linden, New Jersey. A registration inquiry of the white Hyundai Elantra revealed it to be listed to one of multiple vehicles for two individuals. One of the registered owners listed the white Hyundai Elantra online for rental purposes. Bynum's call detail records revealed communications on January 31st, 2023, a day prior to the victim's murder, with a phone number related to one of the registered owners of the Hyundai Elantra. Those communications, a rental agreement, photographs of Bynum, and a photograph of Bynum's driver's license and a statement from the registered owner all confirmed Bynum made a cash transaction and rented the white Hyundai Elantra on January 31st, 2023 in Virginia. Bynum's transaction and rented, Bynum's device record showed on February 1st, 2023, Bynum traveled from Virginia area to New Jersey and immediately after the murder returned to Virginia, specifically to a Smithfield address, where it was later determined his girlfriend resided. It should be noted that the Smithfield address was also listed by Bynum under a customer account with the United States Postal Service. On May 29, 2023, an arrest warrant was issued for Rashid Bynum for the murder of Eunice Junfor. On May 30th, 2023, members of the Chesapeake Sheriff's Department and the Chesapeake Police Department observed Rashid Bynum on a front porch of a residence located in Chesapeake, Virginia, and subsequently effectuated an arrest of Bynum. On this same date, a search warrant was executed for the Smithfield address. At the residence, located inside of a black fanny pack belonging to Rashid Bynum, a Glock 19 handgun and firearm magazine was recovered. This Glock 19 handgun was transported to the New Jersey State Police Ballistics Laboratory, where they conducted a microscopic comparison of the 14 discharge cartridge casings recovered from the murder location against test cartridges from the Glock 19 pistol seized from the Smithfield address. The results of the examination concluded that the 14 cartridge casings from the murder location were identified as being discharged from the same Glock 19 pistol that was located inside the black fanny pack from the Smithfield address. Your Honor, based on this information, the state believes that their weight of the case is strong. While counsel mentions that we have not provided a motive, it is not the state's obligation to explain to the defense why someone does something. We are here to make sure it's clear, not only to the defense, but to the people, that this is the person who committed the offense, not why. So with that information, Your Honor, the state believes that in addition to establishing the weight of the case, we also have other factors that need to be reviewed, frankly, when we discuss whether or not defense counsel mentions PC, but there's other factors that we consider when we talk about detaining someone. We discuss the risk of the public safety, we discuss risk of flight, we discuss someone's PSA score, we discuss the seriousness of the charges, and we discuss the record of the defendant.
Before we go there, just to address the weight of the evidence, he was picked up on Easy Pass detectors. What about the motor vehicle with tag readers?
Correct, Your Honor.
Do you have
Those are
any
the
of
tag.
those?
Yes, Your Honor. That
What
was
did that show?
The tag reader showed that in addition to the vehicle being in the area leaving the scene, leaving the murder scene at the time frame, that it also picked up in Newark, New Jersey, Woodbridge, and Linden. And it should be noted that the church, their main headquarters is located in Newark, New Jersey.
Right. And then you indicated that the cell tower dump disclosed Mr. Bynum's cell phone number, correct?
It disclosed a device that was associated with
And
it.
then based on that, you obtained a geofence for the location of the homicide, correct?
Well, first we obtained the geofence so that we could get that information, and obviously the cell tower dumps. Both of those gave us the information that had to do with Mr.
Was
Bynum.
Mr. Bynum's phone at the location based on the geofence at the time of the homicide?
It was in the area at the time of the homicide, yes, Your Honor. In addition to
In that
another,
location?
yes, Your Honor.
Okay. And what is, have you ascertained the relationship between the defendant and the victim?
Your Honor, based on the accounts from the witnesses, Mr. Bynum and the victim did know each other. Specifically, they met years ago when the victim was recruiting to have members join the church. Mr. Bynum was one of the individuals that was recruited to join the church. He was recruited in Virginia. After being recruited, he was brought back up to New Jersey. He had actually resided with the victim for some time, as well as her daughter and other individuals that were members of the church. At that point, there were certain things that the church wanted to be done, to continue to educate yourself and to continue to be one with the church and read the scripture and so forth that they were affiliated with. Unfortunately, it became apparent to some of the church members that Mr. Bynum was not, for lack of a better way of saying it, not joining the church the way that they felt was in the line with what they had hoped for the intention of his membership. And after some time, he was told to then return to Virginia because they didn't believe that he was following the church's practices the way that they had seen fit.
And you indicated, I don't know if you had said it or it was in the affidavit of probable cause, that the defendant's email was in the victim's cell phone.
Email and yes, sure, email. That counsel
His
mentioned the
email,
King Ra email address. And again, the victim actually had the name of the defendant as King Ra in FCF.
Or with his email address?
With the email address, Your Honor, as well as, again, the phone number that.
And his phone number was in?
That specific phone number was not in her phone. It was that email address, that contact information.
That's the connection on her phone?
Correct. And there was a phone number, it just was not a current phone number that this was.
Determined whether it was an older phone number from Mr. Bynum?
Correct. It appeared to be just an older phone number.
All right, you want to continue? Did you want to say anything else?
Your Honor, I do want to go through the other factors that are considered by the court. First, this defendant had a PSA score of a 3 listed
That's a what?
as a 3, meaning, Your Honor, 3 for a failure to appear and a 3 for new criminal activity. I do see on the manual PSA that there was actually 2.
That's inaccurate.
Right, but exactly, Your
That
Honor.
was prepared before the pretrial services had sufficient information to generate the actual PSA.
Yes. So then the state concluded that it was a 3-3, and also they recommended no release, Your Honor. In addition, that is a factor that's considered under the statute, the recommendation from pretrial services. In addition, Your Honor, the risk of flight. I mean, we've talked about this for a moment, but I want it to be clear for the record. Here we have a case where immediately coming into our state from Virginia to New Jersey, and then immediately fleeing back to Virginia in order to evade apprehension, avoid law enforcement picking up. It is a poster child of flight. The defendant hid in Virginia, stayed there, and it was not until the efforts of multiple law enforcement officers came together in order to bring him back from Virginia to be here. And even once he was arrested on May 30th, Your Honor, you have this individual fighting extradition to come back to New Jersey to be held accountable for these charges for over 8 weeks. And it took efforts in order to get him back here, in order to have this day that we have here for this detention hearing. In addition, Your Honor, the state wants to go through the defendant's record when we talk about the likelihood of release or the public safety requirement. This defendant has a multi-state criminal history. This defendant has a criminal handgun on his person from Maryland that he picked up on June 10th of 2019. He has from Virginia a criminal case history from March 13th of 2015 for a concealed weapon carrying. And while the outline of the PSA has them listed as misdemeanors for whatever reason, the reality is they're still related to handguns and weapons, and frankly, just the failure of the defendant to comply with the provisions for those particular weapons for those instant cases. In addition to that, Your Honor, we have on May 5th, 2023, 2 active restraining orders against this defendant for 2 separate individuals. Now again, the PSA again did not list that, and that may be because they are from out of state. However, on May 5th, we were able to go through an NCIC check and found that 2 separate individuals filed for restraining orders against this defendant. Now, I note that to say, Your Honor, that this is after our homicide. So we are talking about after the brutal murder of the victim. We have, within 2 months, the defendant getting restraining orders filed against him by 2 separate other individuals. This is extremely alarming to the state, and frankly, it should be to the court in regards to the public safety with this defendant being released. And then also, Your Honor, the PSA has listed the July 11, 2019 failure to appear of the defendant to a court date that he had for an unrelated matter. Your Honor, the state also wants to go over the fact that the severity of these charges, while we have listed under the statute that any first or second degree offense or nearer offense would hold that there is a rebuttable presumption of detention, here for murder, it is actually listed out as one of the specific charges where a defendant should be detained unless they can rebut the presumption of detention. Your Honor, not only is it the charge of murder, we have here someone who planned, premeditated, drove hours from one state to our state, came here, lied in wait, and ambushed an unassuming individual, young lady, in her car while she was waiting outside of her home, right after she had let her daughter and friend go inside of the home, and ambushed this woman and shot her 14 times, basically unloading the entire clip of the magazine, and then got back into his vehicle, and then he drove back to his state where he hid until the state was able to get him from his location in Virginia. I could say, Your Honor, there could be no more serious case when someone lies to ambush another.
Where was she shot?
Your Honor, she was shot throughout her body. She was inside of her vehicle. The bullets went through the vehicle, and she was shot throughout her body.
Numerous shots.
Numerous shots. Again, Your Honor, 14 times. So at this point, Your Honor, the state believes that while defense counsel can continue to bring up the 6,000 pages of discovery, it is very clear here that when we talk about the detention hearing and the defendant's release, that there could be hundreds of letters that defense counsel can come up with, and he can bring all the recommendations. But the reality is, Your Honor, in this case, if there were ever a case when we discuss someone being detained until their trial, this defendant, Rashid Bynum, should be the defendant that is detained for the safety of the community, to ensure he appears, that he's here, and frankly, to stand and be held accountable for these charges that we have before you.
Thank you. All right. Defendant Rashid Bynum was detained for the reasons based on straight. Defendant is present before me for a detention hearing. His PSA score is 3 for failure to appear and 3 for criminal activity with a recommendation for no release due to the nature of the charge. There is no elevated risk of violence flag on his public safety assessment. He's 29 years old. He previously failed to appear in a Virginia court proceeding on May 21st, 2019. He has a conviction in Virginia for carrying a concealed weapon, for which he received a 90-day jail sentence. He also has a conviction in Maryland on June 10th, 2019 for possession of a handgun, for which he received a 17-month prison sentence. These convictions would be considered graves offenses in New Jersey and would be treated far more severely. Defendant has been indicted for murder, a first-degree crime, for which defendant is subject to a term of life imprisonment, as well as the unlawful possession of a handgun and possession of a handgun for unlawful purposes, both Graves Act offenses. The court finds that probable cause has been established by the return of an indictment. Accordingly, the burden is on defendant to prove by a preponderance of the evidence that pretrial detention is unnecessary to reasonably assure his appearance in court when required, protect the community, and that it will not obstruct or attempt to obstruct the criminal justice process. The state alleges that on February 1, 2023, the defendant came upon the victim, approached her as she sat in her car, and fired approximately 14 shots at her point blank, striking her throughout her body. She immediately succumbed to her injuries. It appears the victim and the defendant knew each other through their church connections. And defendant was also listed as a contact on the victim's cell phone. The evidence proffered by the state suggests that the defendant immediately fled to Virginia after he shot the victim. It appears that he had arrived earlier that day before the interaction with the victim. His presence at the murder or homicide location has been confirmed through both cell tower and geofence data. The descriptions of defendant and his car are consistent with witness accounts. The defendant had traveled to New Jersey and back to Virginia on the day of the homicide, and this is corroborated by Easy Pass records, by tag readers, by cell tower records, connected to a car and an electronic device, both associated with defendant. A Glock 19 9mm handgun was recovered at the time of the defendant's arrest pursuant to the execution of a search warrant. It was found in a fanny pack belonging to the defendant. A ballistics examination of that handgun indicates that the victim, in this case, was shot by that handgun, recovered, and connected to the defendant. The defense proffers that the lack of an eyewitness identification and a motive here undermines the strength of the state's case. And that the state's reliance on electronic data such as Easy Pass readers, tag readers, cell tower data, geofence data, defendant's communication with others, his internet search, reliance on that information, those facts, is misplaced. Frankly, in my view, the state's proof in this case, the state's proofs are strong and compelling. Defendant, who appears to be a current resident of Virginia, arrived in New Jersey on February 1, the day of the alleged homicide, and fled back that same day to Virginia. He has no current connection to the states. No Johnson factors have been presented in support of the defendant's pretrial release. He wasn't, in this case, apprehended for 3 months until May 30th, and he resisted his extradition back to New Jersey to address the charges. Accordingly, he wasn't returned here until July 27th, only after the execution of the governor's warrant. Based on the totality of the circumstances, including the brutally horrific nature of the crime and the weight of the evidence, this court finds that the defendant has failed to rebut the presumption for detention with the proof necessary to show that he does not pose a danger to the community, a risk to obstruct the criminal justice process, and a risk to not appear in court. Accordingly, the state's motion to detain defendant is granted. The defendant has within 7 days the right to appeal this detention decision. We're coming back on what date, Clay?
October 30th.
All right, we'll see you on October 30th. Thank you.
Thank you very much, Your Honor.
All right, yeah, the excludable time, the clock starts today, right? So up until,
He was arraigned.
right, it was arraigned today, but he's been held because there should be an excludable time order from when the time of his arrest until today.
Well, Your Honor, the time.
Clock starts running today.
The clock starts today, correct. It starts today. The time that that the defendant was in Virginia, all of that time is not attributable to our time period.
What he says, the clock will start on August 30th.
August 30th. Why is that? It starts today.
Yeah, because
Well, she's my boss, so I can't say otherwise.
Judge, I'm on. Judge, although the defendant gets officially detained, it goes back to when the time of his arrest. When he would have been committed at that time. So once it goes into the system, that's when the clock would have started.
He's arraigned today, he's detained today.
His 90 days starts at the time of his 180 starts at the time of the event. We still have to
Well,
account for
you're talking about I guess this is from the time of the arraignment. Well, he's arraigned today.
Yes.
So today's arraignment
Yes,
day.
but then there's also, Judge, we want to account for the pre-indictment time as well. So there should be excludable time entered into that. There should be excludable time entered since he did not come up from 8:30 to the present.
Right. Posted,
today.
well, it's almost moved now because he's been indicted. So post arraignment, there is no excludable time at this point. There is no excludable time.
No, not at this point, yes.
So,
But if we look for the pre to make it accurate and a clear record,
Right.
then there would be for the
For
pre.
your record-keeping purposes, there's excludable time. Notwithstanding, it's moot because he's already been indicted. It's of no issue, right?
Correct, Your Honor. The state's only concern is that when we talk about having an extended out initial disposition conference to October 30th, at this point, Your Honor, because that's obviously defense's request, because he needs to review the 6,000 pages of discovery. At this point, the state does not want all of that time to count against the state, when the state right now is prepared to go forward within a month of what the court has provided.
All right.
Judge, the defendant takes no position at this time. I have to evaluate exactly what's been said here in order to determine what position we take with respect to the issue of excludable time.
Well, what Ms.
understand
Gibbs
what the
Ms.
court
Gibbs
said.
is saying is essentially that I shouldn't give you 8 weeks. I should take some of that away and make that excludable time because maybe we should bring this case back in a month or 6 weeks and not 8
Your Honor,
weeks.
really, Your Honor, the defense counsel can have as much time as he needs, but what the state is saying is it should be
Right, I
excludable
understand that, I
time,
understand
not
that.
against the state.
So how much time are you looking on excludable time? 2 weeks?
Your Honor, I think normally we bring an initial back in about 30 days, and so,
4 to 6 weeks.
4 to 6 weeks.
Okay.
And so
Do
there
you have
are,
an objection to 2 weeks of excludable time against the client?
No.
Okay, so we'll enter 2 weeks of excludable time. All right. Anything else?
no, thank you very much, Your Honor.
Thank you.
Thank you, Ms. Ashley. Thank you, Ms. Gibbs.